So once that DNA test comes back negative, is that when I would go ahead and put the other father, or can I go ahead and start that process since we already know?
Yes, sir. I'm right here.
Thank you. And try to find a spot, don't move around because I don't want you to lose that cell signal, sir. Okay. Here we go. All right, folks. This is Bell 25 DFAN 352,262. This is in the 264th Judicial District Court of Bell County, Texas. As in the interest of early minor child, non-custodial party is Jakari L. Early. Custodial party is Marche D. Green. And this matters before the court on a original petition and suit affecting parent-child relationship with an announced paternity. The court will note for the record that both parties signed requests for hearings, which pushed them properly before the court without any service citation. And so at this time, we can go ahead and proceed at this point. And I'll ask the state for an opening to tell the court what the state's requesting we do here today. And I think my assistant explained this may be the case. I'm thinking it is. I want to confirm that this may be the one dealing with private DNA. So at this time, Mr. Welch, I'll let you go ahead and proceed. Thank you.
Correct, Your Honor. This is the case with the private DNA. So there's an acknowledgement of paternity in this case. It was already filed with the court, and the state asked the court to take judicial notice of it.
All right, it's attached to the pleadings. Let me see.
Yes, Your Honor.
Okay.
All right, guys, buckle up. This courtroom just got real. The judge calls out a tense paternity case involving Jakari Early and Mayor Green. The room is quiet, but the air feels heavy with truth waiting to surface. The state attorney steps forward, announcing this case involves a private DNA test. Everyone knows what's at stake: a child's identity, a parent's future. As the judge takes judicial notice, eyes shift nervously. The moment has come to separate assumptions from facts, and the clock is ticking fast.
Hey. So not very thick, so. All right, yes, the court will take judicial notice of the filing of exhibit number A with the original petition that shows announced paternity introduced and signed off on by the parties back in, looks like October of 2020.
Thank you, Your Honor. So Jay understands that the parties apparently, or at least the father, Mr. Early, and the child, Jakai Early, they did a private DNA test. It was through the DDC. It looks kind of like ours. Apparently in Ohio, through any lab test now, that shows that DNA is negative. Now, Your Honor,
is it a dual draw or just a parental draw? I'm sorry, a father draw only.
It's a father only.
Okay. All right. You may proceed.
And Your Honor, the reason I didn't, offer it or put into evidence is because
here's where things start heating up. The father claims a DNA test came back negative, but wait, the test was done privately, without proper legal protocol. The court isn't having it. The judge wants mom, dad, and child officially tested through the state's custody chain. No shortcuts, no excuses. The tension rises. Everyone knows that one result could destroy everything someone believed for years. The courtroom becomes a stage for truth, and every eye is locked on the judge's next command.
Didn't want to get the docket confused, and I think they all agree that it's there anyway. So, Your Honor, the state has to object to the ordering of DNA, which is what Ms. Green and Mr. Early would like.
Right.
But I'm not going to strongly object, Your Honor.
Well, and the court's always going to do what's in the best interest of the child. It's the best interest of the child to know who the child's father is. So I'm going to go ahead and grant the new some brand new DNA testing. Obviously, I want mom drawn, I want the child drawn, I want dad drawn. But until then, I'm just going to do a DNA test. I'm not going to set up any temporary order, and we're going to get a chain of custody that gets us through all the legal requirements. And in the interim, ma'am, if you can get with the state, back with the state, with who the proper party might be, we can go ahead and start getting. They can start getting the necessary paperwork filed. So at this time, Mr. Early and Ms. Green, I'm going to go ahead and grant this brand new paternity test on this because this is in your child's best interest for me to do so. and we'll get it set up and get y'all reset probably somewhere 6 to 8 weeks out and get that results back. And if it's still the same, then obviously we will find that Mr. Early's not the father and move on from there, ma'am. Okay. I'll start with you, ma'am. Ms. Green, any questions?
So once that DNA test comes back negative, is that when I would go ahead and put the other father, or can I go ahead and start?
Boom. The judge takes control and drops the hammer. A brand new paternity test is ordered. It's in the best interest of the child, he says firmly. The mother nervously asks if she can already name the other possible father. The judge allows it, urging her to move quickly. He even jokes about AI faking history, but there's no fake here. This is real life, real family, and real consequences. The judge's tone softens for a second, but everyone knows truth is coming whether they're ready or not.
That process, since we already know.
That's probably you can already let the state know who you know the father is, and they can start getting ready. Because again, this is if you recall, this time it probably took 2 to 3, 4 months for this to get to court to begin with. So let's get a jump on that one, because we know we've got a pretty good idea that's going to come back negative. But again, folks, ma'am, I've been all last week I was fooling around with AI, and I can get AI that shows that I was the #1 draft pick for the Dallas Cowboys in 1975. Okay, and I guarantee you I was not. All right.
Okay.
So yeah. So anyway, let's go ahead and get that set up and get the chain of custody. They'll get us to point A, from point A to point B. And Mr. Welch, if y'all, it's not against y'all's policy to start getting that information together so we can get this, because like I said, the child in this matter is what now, he's going to be 3, he's going to be 2 in October. So yeah, let's try to get this going where we can get the right party in here. All right.
Yes, Your Honor. And ma'am, I don't know if you already sent this to you, but we'll send you a form, attorney information gathering form, and you can give us information about the true biological father if Mr. Early isn't the father. So we'll get that going joint, and then file a new pleading, I guess, with the new father, probably. So all right, and then Your Honor, for the reset date,
Let's do something about is Mr. Early still in Ohio?
No, sorry, I don't mean to interrupt, but no, sir, I never took the test in Ohio. I believe that's just where they
Oh, okay.
I don't know yet.
Where are you located?
I had the test done in Harker Heights, Texas.
Okay, yeah, I use the same facility you did. Both of y'all are local, so
Yes.
Mr. Welch, look at setting this one out about somewhere between 40 and 45 days and 60 days, because they're both local. We get that draw done ASAP and get that one back before the court.
yes, Your Honor. All right. So Ms. Green, Mr. Early, just wait in the breakout room. I'm going to, well, someone will send you a DNA order with the reset date and the Zoom code. And then
All right, guys, things just got intense. The judge orders the DNA draw to happen ASAP. No more waiting months. Both parents live nearby, so there's no excuse for delay. The state's attorney steps up, promising to send official forms and start identifying the real biological father. The energy shifts from denial to determination. The mother looks anxious, the father silent. You can almost hear their thoughts. What if the truth really changes everything? The judge's focus is clear: fix this fast and fix it right.
assuming the test is negative, then we'll probably do an order against paternity for Mr. Early or something else like that.
Yeah, I can find that he's not dead. So yeah, it's not the first time this has happened. So and Mr. Welch, I'm not sure if y'all still able to do that. If y'all can right now check when to see the appointments that can be made locally for DNA tests, maybe even get that set up today before these folks get out of here. Okay.
Yes, Your Honor. And one of our DNA experts will come and talk to you. And she'll go through the ropes.
All right. See, back in the good old live days, they would be sitting here right in the courtroom, so we can get that done before y'all even left. So, but hopefully we can still can do the same thing online. All right. All right, folks. I'll go ahead and let the state get y'all set up. We'll see y'all in about somewhere between 6 and 8 weeks, and we will hopefully conclude this correctly. And like I said, man, I'm getting started on the right person. All right. And I'll start. I'm sorry, Mr. I didn't give you the opportunity. You have any questions, sir?
No, sir.
And Ms. Green, do you have any other questions, ma'am?
No, sir, I don't.
All right, anything else, Mr. Welch?
No, Your Honor. Thank you.
All right, let's get everybody back into a breakout room, and we'll get you folks all the information y'all need, and then after that, y'all free to go, okay? Thank you
Yes.
very much, and we're off the record.
Thank you.
All right. Let's move y'all away.
And there it is, the final call. The judge resets the case for 6 to 8 weeks. Everyone will return once the DNA truth is out. The court clerk prepares to send the order, and you can feel the weight of reality sink in. The judge dismisses them calmly, but his words echo like a warning. Let's get started on the right person. As the parties log off, the tension finally breaks. But one question still lingers when that test result drops. Who's really going to walk away free?